Hey guys, today I will tell you about property laws in India. In India, there are various laws that deal with property in India, some of which are as follows. Transfer of Property Act 1882. The Transfer of Property Act 1882 is an Indian legislation which regulates the transfer of property in India. It contains specific provisions regarding what constitutes a transfer and the condition attached thereto. It came into force on July 1st, 1882. According to that, transfer of property means an act by which a person conveys the property to one or more person or himself and one or more other person. The act of transfer may be done in the present or for the future. The person may include an individual, company or association or body of individual, and any kind of property may be transferred, including the transfer of immovable property. Second, Partition Act 1893. Under the Partition Act, in case of a suit of partition, if it appears to the court that the partition of the property control reasonably happen or also or sale of the property is more beneficial, than the court may on the request of the shareholders interested direct the sale of property and distribution of proceeds. Section 9 of the act gives power to the court to distribute the property equally and make the sale of remainder property and to distribute the proceed under the 1886th Law Commission report on Partition Act 1893. Various suggestions have been made to amend the act as there are gaps in the act, but the amendment is yet to be made. Third, Indian Succession Act 1925. The Indian Succession Act deals with two kinds of succession: testamentary succession and estate succession. Testamentary succession is where a person makes a written document called will as to whom his property will go after his death. In case there is no such written document, the properties of the deceased would be distributed according to his religious law, and this is known as estate succession. In case there is no personal law applicable to the person, the Indian Succession Act would apply. Likewise, the Indian Succession Act is applicable to Christian for both kinds of succession, whereas in the case of Buddhist, only the testamentary succession laws are applicable. As per the Indian Succession Act, in the case of Christianity, the hired religion is immaterial, but the person who is dead must be a Christian on the date of his death. Adding to this, the adopted child will not have the same right as the biological child. Hindus Succession Act 1956. Hindu Succession Act governs the Hindus as the name suggests. According to the act, the person who converts into any other religion can still claim his share in the ancestral property, but the child of the converted person cannot. Hmm. Muslim Personal Law Shariat Application Act 1937. The Muslim Personal Law Shariat Application Act applies in the case where both the parties are Muslim, even if the son has converted into another religion. He is the biological son who has a right to claim over the ancestral property. The act also states that if the child is born out of wedlock, he has the right to claim over the ancestral property. What kind of properties can be partitioned? There are two types of properties that can be partitioned as per the property partition laws in India. First, self-acquired property. Self-acquired property is the property that a person acquires with his own hard-earned money and is not has also any property.